medics, and other countries followed suit. The United Nations created a new
was diverse. It was
so
people from everywhere.
All the sessions, there were different panels. But the political session, I was there with Dr. Omane Boama, Joyce Moktare, Kofi Tonto, NCC chair, and some other representatives. Yeah. So it was very balanced, and it adds to the work we've been doing. And even after we came up with the drafts, we even had stakeholder engagements with Meta, Facebook, with TikTok, with DW Academy. A lot of institutions made inputs into the draft broadcasting bill and also the plan. And that is why one of the issues that we are seeking to address, among the issues, I've mentioned some already. One has to do with enhancing ethics and professionalism in media. And even our international organizations have become concerned when it comes to issues of professionalism. At first, when we go for summits and conventions, everyone is talking about government. But now they are saying no. We think everybody must contribute positively to the solutions. So we are using proactive approaches to reach out to the media platforms, the app developers, and no way to be doing monitoring and let things happen before we do the reporting. We are also working on a protocol on how to report misinformation and disinformation on online platforms. Meta, through their West Africa Director for Policy, informed us that in Ghana, Meta has selected Dubawa as a fact-checking partner. So when issues that are becoming sensational, they are able to reach out to say, is this authentic or is it fake? So there are strategies, and we are hoping that when upon Cabinet's consideration and approval, we will still do more sessions to make sure all the stakeholders, including political parties, because I remember I saw CPP representatives at last year's conference. So it's my prayer that we will all contribute positively. And also as corporate Ghana, if there is a brand that is always, or an influencer, always churning out negativity, insulting cheese, insulting everybody, telling people to use Kayamata, do this, you don't go and take such a person as a brand ambassador and give them reward the person and set the example that a lot of young people will look at the person and say, oh, this route is good. The next moment, everybody is saying, my boyfriend once said, you haven't seen everybody. So and it's so painful to watch.
We should be able to. So very interesting developments coming up there. Let's transition now, and let me do this quickly. So the time is now. Business and Financial Times, in partnership with KPMG and Arthur Energy as exclusive knowledge partners, brings to you the 13th edition of Ghana Economic Forum on the theme Unlocking Opportunities, Re-engineering Ghana's Economic Model for Sustainable Development. The date is the 8th of August 2024 at the Mövenpick Ambassador Hotel at 9 a.m. This year's event aims to bring out new critical thinking and policy alternatives to help shape the country's economic transformation and sustainable agenda. So the guest speaker, Dr. Ernest Addison, he's the governor of the Bank of Ghana. The Ghana Economic Forum is powered by the Business and Financial Times with support from Fidelity Bank, Olam Agric, Omni, BSIC Bank, and Minerals Income Investment Fund. Media partners are Sasi Radio, TV3, CDFM, 3FM, Happy FM, YFM, ZFM. You can call 020 9457 427. The number again is 020 9457 427 or 0244 47 6376. That again is 0244 47 6376, or visit www.ghanaeconomicforum.com for further details. So GEF 2024 Ghana Fest, and that is the Ghana Economic Forum coming up under the auspices of the Business and Financial Times. And so, are you ready to elevate your style with unmatched elegance? Discover your Paul Bespoken collections, where your wardrobe dreams become a luxury reality. Handkerchiefs with precision and tailored to perfection and designed uniquely for you. Step into a world of bespoken excellence, from the finest fabric to impeccable details. Your Paul ensures every piece reflects your individuality. Feel confident, feel sophisticated, feel your Paul. Visit us today at 54 Dade Street, Laboni, or call us on 02055 7768658. That number again is 055 776 8658. Yapol by Sock and Tie. Yes, so yes, they are just around our corner here. Visit them and get your stuff from them. So let me quickly deal with this. Yes.
Do you have another frequency?
We have Asasipa.
Is that new?
Yes, Asasipa is 107.3. It's our tree station.
Is it new?
It's new, yes. We haven't started full operations.
And I wasn't sure.
That's the studio next to us. That's the Asasipa studio.
It's supposed TV studio.
No. There's a studio. There's a studio from here. The TV is coming. Okay, so Asante says that Wilberforce, let me and Mr. Jantua understand that under no circumstance should anyone ever entertain a document that seeks to cast aspersions or denigration to a particular tribe in Ghana. It's very dangerous for the peace of the country. Yes, I think the panel all agree, Asante. Thank you for your message. George says that Mr. Jantua knows that nobody puts his plan to steal, and nobody puts his plan to steal and put it in a document. Anybody who believes this document should be checked in the head.
That is project 2025. It's being done in a Republican.
Okay.
Yeah, it's actually more sensible to put your plans on paper.
From beginning, it was supposed to be a secret document.
So Samuel says that the most pathetic aspect of this saga is that the most enlightened class are rather the people who are championing this issue. So he says that God have mercy. Wilberforce lawyer Ishak is right. The NDC is going round and saying DMB is just being used as a conduit. The NDC cannot come with policy and debate the issues. Is that stock in trade? Is their stock in trade? Okay, they have lost the debate. Okay, so Donson says that most dangerous political party in the world is NDC. Instead of them explaining 24-hour economy, they are rather prefer telling lies, propaganda, never again. Okay, so Jerry Ajalolo Sr. says that God bless the womb that bore the lady information minister. Hey, Charlie, this is a high-profile endorsement, Hajia, from Jerry Ajalolo Sr. You know this man. Okay, all right. That's a very high profile recommendation. Yes, Jerry's father. Okay, misinformation and disinformation are sweet when you are the one propelling it in opposition to win power. The political party should be thinking on how to sanitize the space and do issues-based politics, and not the name calling and insults that we see around. And that is Baba Al Hassan. Baba, thank you for your message. And then Honorable Fatima, you said it correctly. I would plead with you to strengthen the public information service to educate the citizen on some of these vices. They pollute our ecosystem. And if need cares to know, there is no politician in contemporary Ghanaian politics who has suffered name calling than the current president, and that is Baba Chairman from Tamale. Okay, so let's transition, and we are starting with you again.
He's been the longest.
Yes, he's been the longest. Yes, obviously. So, this week, the Court of Appeal came up with the most dramatic decision ever of this whole legal year, the 2020.
Why was it
2023 and 2024.
Let him learn.
I am the one asking the questions. Let me finish.
No, but your question, the way you ask it.
If he disagrees with my preamble,
when you get an opportunity, you can respond to that.
If he disagrees with my preamble, that is fine. And just notice that, gentlemen and lady, everybody has 5 minutes on this matter. You can't go beyond 5 minutes because the time is up. So the Court of Appeal's dramatic decision to as it were, acquit and discharge 2 accused persons who are standing trial, who a court of competent jurisdiction said they had a case to answer. Another court of competent jurisdiction says that they don't have a case to answer. I know in your political party they seem to be rejoicing about the development. What really do you think of this decision the Court of Appeal made? Me first, 5 minutes. After 5 minutes, I'll cut you.
I've always heard that the opinion that interlocutory appeals should always be allowed to be exhausted before the substantive matter continues. There's a principle of securing the rights of an accused person. An accused person is always a vulnerable person. You understand? And so when the prosecution has closed this case and the court rules that you have a case to answer, my position has always been that once the interlocutory appeals end at the Court of Appeal, the court system should be activated in a manner that makes it possible once the person has chosen to exercise his right of appeal. The trial court must stay and allow the appeal process, because other than that, we waste state resources. And this is what has happened. Because whilst the interlocutory appeal was ongoing, the trial was ongoing. To the point where we've had to, and judicial time is precious time. This is a Court of Appeal judge sitting as an additional High Court judge. Means that we have to make space, we have to employ technology, we even had to do live streaming of the court proceedings. What will it have taken for, since we are now doing the e-justice, and I want to appeal to the Chief Justice that one of the biggest headaches we have is how to compile our records in time. If there's a way, now that we scan our documents, if we can either invite private sector participation so that when somebody files a notice of appeal, within a week, maximum 2 weeks, the record of appeal should be ready. So imagine that Dr. Atuforsen had filed his notice of appeal. The record of appeal was ready within 2 weeks. A panel had been set up. The decision would have been rendered before the trial will progress. That is what I think, seriously, because it prevents us from, as we saw in this case, wasting time. We allowed the trial to proceed, witnesses have been called, then the Court of Appeal comes in with the hammer that there's no case to answer. You see, because the trial court is not a final court. Its work is subject to the appellate process. And I want to say that this is one of the instances where it reaffirms my belief in the fact that the architecture where we have the review system, where we have the appellate system, is a good system because it allows for a review of the work of the trial court. You understand? And quite coincidentally, she's even a Court of Appeal judge sitting as an additional High Court judge. Now, if you want to look at the merits of the decision, I think it boils down to two main things. One, whether in the respect of Dr. Atuforsen's case, I think it settles a few principles of law for us as teachers, which is good. When an official, and especially with the principles of criminal law, has to do with the burden of proof. You see, with criminal law, I always say that with criminal law, it's very precise. It's 1 + 1. You understand? There's no room, unlike other forms of law, like yeah. You know, when we do land law and other things, where you are allowed to, come out with persuasive arguments and no. The burden and the responsibility for proving what it must be precise, and I think that is what the especially Justice Akabuafu, and I always loved his writing, the way he puts this, and you could see his bias towards the Canadian, because he's Canadian trained. He always cites a lot of Canadian cases, in his judgment. Of course, they are of persuasive effect. But the way he dealt with the allocation of the burden of proof for me was very important. And of course, Justice Bright-Mensah as well. These are experienced judges in respect of criminal jurisprudence in this country. You see, because there has been some decisions had made it look like when it comes to the burden of proof, and I'm sorry if I've taken our listeners to the classroom, when it comes to the burden of proof, you understand, in criminal cases, the standard is that you must prove beyond reasonable all reasonable doubt, and
not at that stage.
No. So there's, you must establish a prima facie case. So, but you see, the prima facie case, the nature of the prima facie case is what had been in debate in certain cases, where what is it that the prosecution has to prove in order for the burden to shift to the defendant. That had been the debate. In this particular case, I thought the court has settled some of the debate that has been out there in some of the decisions. You look at Chatuchikata, if you look at some of the decisions, there seemed to have been some debate about what exactly was the standard of proof and the bedding. Now, in this case, for Dr. Tuforson, the issue was about whether he acted with appropriate authority when he signed the said letter authorizing the payment.
When he caused the issue.
Yeah, the LC.
For the issue of
so
LC,
whether he had the
irrevocable LC.
Whether he had authority. Yeah. The issue is whether in acting for and on behalf of the Minister of Finance, did he have a burden to prove that he had the authority of his boss? Or was there a presumption that once he was conducting an official act, it was a regular act, and that it was the prosecution that had the burden to prove that he did not have the authority of the substantive minister to have acted? That was the debate. The prosecution felt that once they had led evidence that there had been some loss to the state, indeed, the burden now was on Dr. Tuforson to prove that he had the authority of the then sitting minister, to the substantive minister, to have signed the said document. The court said no. If you come to court and make the allegation that somebody has done something, the burden to prove that that person actually did that thing rests on you. It is not the case that you made the allegation, you have led some circumstantial evidence in respect of the fact that and that raises a reasonable doubt, or that raises some, and so down, the burden now shifts on the accused person to prove his innocence, especially when it's not a strict liability offense. Strict liability offenses simply are offenses where, because you are bound by the act, so normally in a criminal case, you must have an intent, and then you must have a prohibited act. So prohibited mind, that is the mens rea. Prohibited act, that is the actus reus. A combination of the two, both prohibited by law, makes it a crime. For strict liability offenses, you are subject to just the prohibited act. So, for example, if you have sexual relations with somebody who is of a certain age, it is a crime. It doesn't matter whether the person consented or whether you had the intention. It doesn't matter. Once the person is of that age, it is a strict liability offense. The court was clear that this was not a strict liability offense. I think it's a lesson for especially our prosecutors, that the burden is always on you. The constitutional provision is that a person is proven innocent and is innocent until proven guilty. And so perhaps once the substantive minister
1 more minute.
Yeah, relax. The substantive minister, this is a point of education for our listeners. The substantive minister, Mr. Setekbe, was alive. The prosecution, if it believed that the said minister had not authorized his deputy to have done the act, because that was the whole thing, that there was no authority. That's the allegation, that the deputy minister had no authority to have initiated that signing of the or the release of the LCs. He should have brought him. On respect of the Mr. Jakpa, the issue about agent, it is a good lesson for those of us also who teach commercial law. The criminal liability of agents as opposed to the principal, who were the parties to the contract. The court was also very clear. Justice Jakpa was merely an agent. He was not a party to the substantive contract. And so the parties or the persons, that's the principal, that is Big C, should have been the ones that should have been in court, being held liable for the actions of the agent. Unless Mr. Jakpa had gone out of his duties as an agent and done things contrary to what he had been assigned to as.
Even if Big C was not incorporated
it is not the issue. The issue for the court was that there were principals to the contract. And so for the agent's duty is to perform his work in accordance with his, with his contract as an agent. Once he does that, he's done. He is not liable for the actions of his principal, because the contracting parties were, and in fact, the other interesting thing was that it was the Ministry of Health that was supposed to have done the pre-shipping inspection. And so it could not have shifted from the Ministry of Health to the Ministry of Finance, whose role only was to authorize payment. I think it is an interesting decision. Yeah. We all have to look at it. You understand? Yeah, because you see, when you
I just have a basic question.
Yes.
The Finance Ministry is seized with holding our monies.
Yes.
And they make payments based on being satisfied that they are supposed to do those payments. They don't just make payments because they are supposed to make it. They must satisfy themselves that the payment they are making is being made in the interest of the state.
Correct.
So if you are Minister of Finance and you cause a letters of credit which is irrevocable to be issued, you are saying that you had no burden to be sure that in issuing a letters of credit, an irrevocable letters of credit, you had no burden to be ensured that all preconditions had been met before it was issued.
And so the contract
I find it quite interesting.
No, that is not
payment after delivery.
No, you don't get the court. The court says that an accused person bears no burden. It is you that made the allegation. You, the state, the republic, and it is important because it is a cornerstone of our criminal jurisprudence.
Okay,
because of the fact that it is the state that has the resources.
Yeah, I just spent more than 10 minutes.
Oh, yes, I know. The state has the burden and the resources to do prosecutions. Yeah. And so when you come after a citizen of the state, you have a burden to bring all your eggs into the court and to be able to prove all the essential elements of the crime. For me, the sad part of this is that there was an opportunity for the state to have made 2 million euros. Maybe and you see, it's also about what it is that we are looking for when it comes to some of these prosecutions.
Yes.
Is it that, and I've always held the opinion that if we can recover, you understand? Yes, I can understand the deterrence effect. You want to deter certain conduct, but where you see the thing about, and I keep emphasizing this, the thing about causing financial loss, especially when it's not a case of stealing, there should be a distinction. When it's not a case of stealing, when the person is personally benefiting from the transaction, and it's about an action, an omission to act, or an action that has caused some financial loss to the state, I believe that what we should be looking at is recovery.
Okay.
So but where the person, in the case where the person has actually dipped his hands into state coffers and stolen money, then you can look at the
I have a different view about that.
Fine.
I have a different view about the causing financial loss to the state and this issue about stealing, because I think the stealing is embedded in it. But that's what I think. But I'm not so here to share my opinion. Yeah. So I'll come to you. Hajia will have the last word. And that's not the law. Yes. Hajia will have the last word on this matter. So I'm coming to you, Counsel, then Mr. Jantua, then Hajia. Yes.
Thank you very much for the opportunity. I think it is important to always put this in context. If you look at throughout the trial, NDC have taken the proceedings to be theirs, and not just the state versus Atufosen, which is quite sad as a country.
But he's a minority leader.
Yes, but if he's a minority, regardless of that, he's still a citizen of the country, and the state is not prosecuting NDC as a party.
What are you saying?
They are dealing with an individual.
It will happen if
because of that,
so you are saying that the issue was made political instead of legal?
They're politicizing.
But the figure person involved is a political figure.
It doesn't matter.
It doesn't matter if we say we are fighting corruption.
Yeah.
Okay.
And they try to impute what they call it a motive to it. I remember listening to the director of legal affairs. He advanced two motives. One was that as soon as Atufosen began to talk about his opposition to e-levy, then the Attorney General immediately activated something that they had gone to EOCO to settle, which is quite misleading. The second one is that the president's daughter is interested in ambulances, and it's one of the reasons. Even they are even contradicting. Now, but that's not how criminal proceedings starts. In the common law countries, there are two tests that guide criminal proceedings. One will be the evidential test. The other one will be the public interest test. Before you take a case to court, the prosecutor needs to ask himself, is there enough evidence that when you go to court, you can adduce those evidence to convince a tribunal of law and a tribunal of fact to find a guilty finding? If the answer is yes, it's not even enough to still go to court. You have to look at what we call the public interest test. Is it in the public interest to even prosecute the individual? For me, the Attorney General have looked at those two tests and they have met. If you look at the press release he has given, he has listed a number of reasons that he thought the Court of Appeal should have rejected this particular appeal, having advanced this thing at the trial court. If you look at them, look at the evidence critically, and the NDC keep advancing a wrong test. It's not true. The Canadian judgment that the Court of Appeal judge cited and our own Ghanaian jurisprudence is borrowed from the English case of R versus Gabriela. If you look at what they said over there, I have taken the opportunity to read the judgment carefully in R versus Gabriela. This is not a summary trial. This is an indictment. And in indictment trial, R versus Gabriela said that at the point of submission of no return, the test is not beyond reasonable doubt. That is not correct. So the Court of Appeal and the NDC advancing the case that it has to be beyond reasonable doubt. It's not true. The test over there is that taking the prosecution evidence at the highest level, is there a likelihood of finding of guilt? Which is a lower bar. It's not a higher bar beyond reasonable standard that they are talking about. And mind you, trial by indictment, the judge over there at that initial point is a tribunal of law, not a tribunal of fact. So the tribunal of fact would at some point, towards conviction, would have to use beyond reasonable doubt. So if you look at what the Attorney General have actually listed, for me, because it's a lower bar, he doesn't need to call the then finance minister. The fact that on paper he signed it would meet that particular test. It's not beyond reasonable doubt. It's not true. So I think the Court of Appeal had it wrong. The High Court judge actually had it correctly.
So now, that is why there's the avenue to appeal at the Supreme Court.
Yes. And then if you come to the public interest, he's not persecuting the guy. For me, the public interest is met here. You can see that he wasn't the only accused. There were second accused.
In fact, there were two other accused persons. Yes, one had to be discharged because of ill health.
That's the second accused I'm talking about.
Yes.
He discharged him he entered nolle prosecutor for him on the grounds of ill health. Because the public interest wouldn't have supported prosecution of a very sick man to still drag him to court, or to even prosecute him in his absence. As he said, there's presumption of what? There's a presumption of innocence. He has a right to listen to the case before him. He should be afforded that opportunity. Trial cannot continue in that particular person's absence. So the public interest wasn't met over there. That is why that particular prosecution was discontinued. But the other two, the public interest is met. Look at the sum of money involved. 2.37 million euros. Of course, it is in the public interest. If a public figure is taking care of our money and he is grossly negligent in allowing the state to suffer that level of loss, why wouldn't it be in the public interest to prosecute such an individual? So I believe it was these two tests that was made. There's no motive behind it. We should stop listening to that kind of propaganda. It's pure propaganda.
Okay, I'm sorry, I have to rush you.
So I believe, to conclude, I believe it is also in the public interest that the Attorney General should appeal, and that will settle the matter. Especially, it seems, though, I said it yesterday, and because two Court of Appeal judges now disagree with each other, even though one was sitting at the High Court. But we now have two split decisions. More or less, I mean, technically it's a split. I know that it's 2-1 in the Court of Appeal. But remember, the High Court judge is also a Court of Appeal judge.
Okay, so you are saying that it's
more or less like a
Court
split.
of Appeal.
Yeah,
dealing with the Court of Appeal.
But what he's saying,
it now still look like a split. So it's in the public interest that they should clarify it.
So there's confusion at the Court of Appeal. That's what he's saying.
The test the Court of Appeal advanced is wrong.
Okay, Mr. Jantua, you also have 5 minutes.
And don't rush me because I'm rushing.
I said you have 5 minutes.
And just on the point of continuous education with regards to what Ni indicated on strict liability, so that people know what strict liability offences are. Some of the strict liability offences got to do with traffic violations, jumping a traffic light. Some have got to do with environmental offences, pollution and illegal dumping. Some have got to do with food safety violations. Some have got to do with building code violations, certain types of fraud, strict liability. Those are examples of it. Now, when you come to the second defendant, who was the Attorney General put a case of nolle prosequi. Could they not have taken his evidence?
Who?
Could they not have taken that second accused who was...
he actually started giving his evidence.
Yes.
And then his ill health...
What did the court say about that one?
Which court?
The appeal court. What did they say about that particular...
No, I don't remember reading anything about Sylvester Imana.
Yes, they did say something about... Because the mere fact that he was part of the establishment should have taken his evidence. The fact that he was sick doesn't mean he couldn't have given his evidence. There are many ways of giving evidence nowadays. Many ways. So for me, that should have taken place. But in terms of the appeal court's ruling, look, I'm trying to pull the case up. In terms of the appeal court's ruling, let's bear in mind that the ruling on the appeal court, and I'll read it, clause 4 of the ruling, it indicated, and it was specific, it indicated, and I quote, it is in respect of the decision made by the trial judge that we are called upon to review the record of appeal and determine whether the trial judge's refusal to uphold the submission of no case is sustainable in law based on the evidence heard. And when you continue to read the ruling, they were able, in the ruling, were able to define what it means by no case. What are the attributes of no case? What are the factors to be considered where there's no case? They also looked at situations where there is a case, the factors, all that is supposed to be done in the ruling, and came to the decision that there was no case. Now, if the Attorney General says he's going to the Supreme Court, let's see what the Supreme Court will say with regards to the depth of the ruling that has been given. So if you realize it didn't go substantially to individuals, but the trial judge's decision. Now, when you look at some of the words that was used by the Attorney General after this case, I was sad.
Why? Perverse,
erroneous.
That is a normal legal language that they always use.
Wait. As the head of the bar, and Madam, what do you call it? Ishak.
Yes.
Correct me if I'm wrong. In law school, they tell you one thing a lawyer should do is to accept rulings of the court, true or false. And I felt that the Attorney General could have handled it in a different way. When President Akufo-Addo lost the 2012 election, 2013 election petition, he took it to court. When he was given his state, what did he say?
He says he disagrees with the court, but he accepts it.
Ha! Couldn't he have used words like that?
But that is the same thing the AG said.
I said, couldn't he have used words like that? Couldn't he have said something and left it there? I found it wasn't nice words to use.
Okay.
I found it wasn't nice.
Okay.
Now, I believe, yes, he has the right to take it to the Supreme Court. But for me, I would have loved a situation where he leaves it as it is. Because
are you saying the court is beyond criticism?
Wait. No, I'm not saying that.
Okay.
I'm not saying that. You can criticize the court.
That the Attorney General should stop pursuing the matter.
I think because this matter hasn't ended. This matter It hasn't ended. If it so happens that these people come back into power, that case will be opened again.
Which case is that?
This one.
Who will open
this one. They will open it again.
They are interested in closing it.
I said they will open it again.
Okay.
For part 2. And what is that part 2? The part 2 is the bit on the spare parts and all that. They'll open it again. It will bring this thing back.
Okay.
It will bring it back.
Okay.
So far as I'm concerned, I think yes, the Chief Justice can take it to the Supreme Court.
No, the Attorney General.
Sorry, the Attorney General. Sorry, not Chief Justice. The Attorney General can take it to the Supreme Court. Let's see what comes out of it. But okay. I feel that at this point, because for me, this case fell on its face the moment that tape came out.
Hey.
Yes, it fell on its face.
Okay, so
it fell on its face. And if you listened to the trial judge's suggestion to the Attorney General, once she listened to that tape, she actually came out and said, recuse yourself. There must have been a reason for that. And for her, from what I deduced from what she was saying, she was saving the sanctity of the Attorney General's office so that confidence in the public will still be there for the Attorney General's office.
Okay.
So
that's right. You have done 6 minutes. So I'm going to end you there. Hajia, you have 7 minutes because you are the only female with us. So you have 8 minutes.
You never told Ishak that he's done 6 minutes.
No, Ishak did 5 minutes.
5 minutes.
Okay. He did 5 minutes.
He went.
Next time, put the clock there.
Okay.
Put the clock there.
Hajia.
Wilberforce. You know.
Yes, you get 20 minutes.
We are left with 8 minutes on the clock.
She's a minister of state.
It is so refreshing to note that our court system is our only remedy when we disagree with each other. And it is also refreshing to note that President Akufo-Addo has not packed the courts, as alleged by former President John Dramani Mahama and the NDC.
And Nipa Kusama.
Wilberforce, the 3 judges who sat on the case, they were all appointed under President Akufo-Addo.
Wow. So they were elevated to the Court of Appeal.
Yes, under President Akufo-Addo. It did not stop them from being impartial and applying the law the way they know how. Since that judgment, I have not heard from any NPP communicator or government appointee insulting the judges. I haven't done that. I have not seen that from anyone. Former President Mahama and the NDC have become notorious for criticizing the judges and the court system when judgments and decisions don't go in their favor. If not for anything, you have heard unanimous 7, you've heard unanimous FC, you've heard a lot of things. They even brought issues about judges and courts, and that the court system in Ghana is ruined. The president is packing the court. There is no impartiality. I thought it was only fair that they would have come out on this occasion, after this favorable judgment, to say, we thought the court was this way, but we thought wrong. It shouldn't be the case that the court is only right when judgments are in favor of former President Mahama and NDC. And when judgments are not in their favor, they are not magnanimous enough. They are not thoughtful enough to say that, you know what, this was not favorable, but the judges could only apply the law. I am saying this because we need to stop bastardizing the court system. We need to stop ruining the only system that is untouched, that still has an image that is intact, because the executive and legislature, we have insulted each other in the public space, we've dirtied ourselves and reduced a lot of offices to where they are not supposed to be. But for the courts, the fact that if you disagree with someone, the fact that if you are accused, you know you can go through the trial court, go through the appellate systems, and judgment will be delivered. I think this case should be a lesson to the NDC, and also to let them know that all the false accusations and misinformation against President Akufo-Addo,
that he is packing the court with NPP people with what was so that they will turn judgments against them. It's not true. And I think on this occasion, I am calling on the former President John Dramani Mahama and the NDC to come out to say they will stop bastardizing the court.
He has described the two judges who ruled in favor as fair-minded.
How is that so? So it means you are only fair when your judgment is favorable to the NDC. That has it not come back to the point that I was making?
Yep.
I am happy that our people are not attacking any judge. I'm happy they are not insulting. No, the Attorney General has issued a statement that he disagrees with the judgment. He has also stated that he intends to pursue an appeal in the matter at the Supreme Court. On this case, he still has the opportunity to appeal. You were referring to the Supreme Court judgment, but that one was not subject to any other appeal. So it is only fair that if he disagrees and there is an opportunity for him to appeal, I believe in due course, if he wants to file notice of appeal and then pursue to put his team and documents together to pursue it, so be it. But my point is that they have said all the law. Uncle Jantua is CNE and Dr. Ishak, you know, they are my seniors. So when they said all the law, I was looking at the other matters. And that is to caution the NDC and former President Mahama and tell them that enough already. Let us leave the court alone for them to do their work. How is it that you describe someone as two people as fair-minded because their judgment is in your favor? Meaning the other one who did not give a favorable decision is not fair-minded. It's an insult. It is an insult.
That's the implication.
It is an insult. It is implied.
No, that's the implication.
It's logic.
It's your implication.
It is logic.
So what about the one who says that the decision is perverse?
So
how would you call that one? The one who actually says that the decision is perverse.
That is a legal
term.
It's a term. It is a legal term.
Are you denying that perverse is a legal term?
I have never used perverse in my legal writings.
Oh, I've
as a
seen
judgment. The judgment is perverse.
Strange.
You can write in a written submission that the judgment of the trial court is perverse. You can't do it.
I've seen.
I've never seen
Okay.
it.
I have.
All right.
So my
yes,
point
Hajia,
is that,
yes.
and please, if I can use the rest of the time to talk about DRIP, it's the most important program executed this year.
Talk about it next.
And we didn't get the opportunity to discuss it.
Okay.
But as we speak today,
But if you talk about it, it's not fair if we can comment about it.
No, it's okay. She's using her time to do it. I'm sorry.
no, let me break on.
You don't know what happens here. There's clear favoritism.
I start talking
There's
about
clear
it.
favoritism.
Just 2 minutes
was
left.
part
The
of the.
minister-
we didn't discuss it.
Here. He has
We didn't
absolute
discuss
control.
it.
I
would also want.
You are wasting Hajia's time.
I also want time to discuss it.
So
I will
let me
ask for
break
5.
communication.
I will ask for 5 more
We
minutes.
are
to her.
aware. We are aware. When Ajia is here, all the rules are put asunder.
If you don't allow her, I'll ask for 5
Yes.
more minutes.
No, you
for her.
are.
Yes.
Please let her finish. You should finish the show.
whole of
You
this-
leave the show for her. Cry. Let's go.
The whole of this budget here.
Let's leave the
I
show
have
for her.
seen a very interesting
Bias.
development, and I think it's also favorable to you. The whole of
You
this
had
year,
10 minutes. Nee.
I've seen something different,
Whoa,
but
12
also
minutes.
interesting. I've been excited about it. President Nana Addo Dankwa Akufo-Addo, through the Ministry of Local Government, Ministry of Roads, and also the District Assembly's Common Fund, came up with this District Road Improvement Program. And the motive is that we have done over 12,000 road projects.
5 minutes.
But beyond that, we still have a lot of community access roads
The
that
Kaswati
need
River, we beg you.
reshaping, that
Finish it.
needs a lot of
Kaswati
development.
River, finish it.
And anytime you need to pursue some of these projects, they also have to go through the same queue with all the big highway projects and urban road projects. So why don't we empower the local assemblies, the works department at the various MMDAs, so that they will be empowered to take up the projects on their own? Yes, in the past there's been times that governments have distributed graders, only graders. But this time around, not only graders, at least 7 equipment per assembly. A grader, a backhoe, a roller, a water tanker, a concrete mixer, among others, so that you are able on your own as a community to do reshaping, to grade and compress, fix some of the streets and roads and potholes, and even some of the drainage systems that we have that are blocked. I'm saying it is interesting because I have seen NDC MPs go to the Black Star Square and use their phones to do live and say that, in fact, they are the ones who brought this equipment. In fact, some of them are saying the contract were executed under former President Mahama. I find it interesting, and it's on a happy note.
Yeah. It's an
that I say
it's a good thing.
by the time President Nana Addo Dankwa Akufo-Addo leaves office in January 2025 and hands over to Dr. Bawumia, all the NDC members will be converted. Do you know why? We've gotten to a point where the NDC has moved from criticizing free SHS to owning free SHS after 7 years of implementation. They have moved from saying President Akufo-Addo has done nothing to claiming district road improvement program as their own after 7 years. Miracles are happening in this country.
Wow.
And it is possible that by January 2025 there. Now it started with the MPs. The rest will come.
Nipapo says that he will change from NDC to MPP if MPP wins the 2024 elections.
He will come. He's on his way.
Okay. So Maxwell Appiah says that the word perverse also means incorrect, wrong, or contradictory.
Thank you.
So what is wrong for the AG to have used such words about the judgment? So that's Maxwell's message. People are complaining about the language of the learned Attorney General Godfred Yeboah-Dameng, and I'm really astonished as you are, Wilberforce. We have had highly toxic and vituperative comments about judgments of the court from the same people complaining today, and I say, how hypocritical can we be? And that is Chum's message. And then Daku again says that lawyer Bobby Benson is head to have said that it will be a disservice to the country if he does not appeal the appeals court decision, especially when it was a majority decision. This I concur, and I know it will be a bloody bath at the Supreme Court. That is Chup Daku's message. Mr. Jantua, as usual, finds what Dameng said wrong, but glorifies what Mr. Mahama's unanimous FC comments. Okay, Mr. Jantua, but me, per your suggestion on exhausting an interrogatory before proceeding to the main trial, I think it will inadvertently prolong same and render the whole trial as not fit for purpose, especially when you have lawyers who have specialization in this field.
If you reduce the time between the notice of appeal and the preparation of the record of appeal, what it simply means is that if the record of appeal is ready and the registrar is able to transmit the record from the High Court to the Court of Appeal within 2 weeks of the decision, and you have filed your notice of appeal, he transmits the record within 2 weeks. You have what, under the rules, you have how many weeks to write your written submission? The rules are clear.
Okay.
If you don't write your written submission, it will be struck out.
Okay.
So
all right.
that at the end of the day, you don't have a situation where we were on the third defendant, accused person, opening his defense with his witnesses testifying, and then the trial is brought to a complete halt because the ruling on the submission of no case was successful. It doesn't make sense.
Okay. All right. So that is how we are going to end our show today. Let me just do this quickly, and then we will be out of your way.
About the bias.
Are you ready to elevate your style with unmatched elegance? Discover your Paul Bespoken collections, where your wardrobe dream becomes a luxury reality. Handkerchiefs with
say the truth, it's your shop.
Precision,
it's your shop.
Tailored to perfection and designed uniquely for you. Into a world of bespoken excellence. From the finest fabric to impeccable details, Yapol ensures every piece reflects your individuality. Feel confident, feel sophisticated, feel Yapol. Visit us today at 54 Dade Street, Laboni. Call 055-7768-658. Yapol by Sock and Tie. And let me just issue the disclaimer that Sock and Tie is not for me. It's not for me.
Supposed to support me.
It is not for me. It is a business activity activity they are doing, and I have a duty to make sure that I mention it, and because they are paying for it.
There's nothing wrong if you have shares in it.
I don't.
Wherever he travels, he brings
I wish I did, but I don't. I don't have that muscle yet.
Exactly. Designer label.
This was a gift. This was a gift.
He just came back from Europe, a European tour. Neither you were on a European tour.
Okay, so that has been our show today. Joining us today is our beautiful Fatima Abubakar.
Yes,
she is the Minister for Information.
Nipapo's girlfriend.
Nipapo's girlfriend. Hajia Fatima Abubakar. Thank you very much for your company. Okay, so Kwame Jantua is a member of the CPP. He's a private legal practitioner. He joined us today. Mr. Jantua, as usual, you are part of the furniture here. We thank you. Nipapo Samoa Ado is also part of the furniture here at Asase Radio. He's a lecturer at the Gimpa Law Faculty, and he's the managing partner at Ado and Ado.
Thank my research assistant, Sebastian.
His research assistant came with him today, Sebastian. Sebastian, thank you. And then the last but not the least is lawyer Ishaq Ibrahim. He is a law lecturer at UPSA. Yes, and also a practicing lawyer in our country. He is a member of the MPP communications team. Thank you very much, Ishaq Ibrahim. This will not be your last time coming here, I can assure you. All right, so that has been our show. This show has been produced by Emmanuel Ohiming together with Daniel Gidiglo. My name is Wilberforce Asari. Thank you very much for the privilege of your company.